You're driving home from work. Nothing unusual. When red and blue lights fill your rearview mirror, you pull over. The officer says you were swerving. Maybe you were, maybe you weren't. But that's not what makes this stop different from every other traffic stop you've had. This time, the officer asks something new. He wants your phone. Not just to look at it, he wants you to unlock it. He wants your password. And suddenly, you're sitting there wondering, do I actually have to give it to him? Can he arrest me if I refuse? Is this even legal? Stick with me, because the answer isn't a simple yes or no. And by the end of this video, you're going to understand something most Americans get completely wrong about their digital privacy. Here's the first thing that surprises almost everyone. Your phone is not just a phone anymore. It's basically a diary, a filing cabinet, a photo album, a bank statement, and a personal journal all packed into one device that fits in your pocket. And the Supreme Court actually recognized this. Back in 2014, in a case called Riley versus California, the justices ruled unanimously that police generally cannot search the contents of your cell phone without a warrant, even if you've been lawfully arrested. Chief Justice John Roberts basically said that modern phones hold so much personal information that searching one is nothing like searching a wallet or a pack of cigarettes found in someone's pocket. That case changed everything about how courts think about digital privacy. But here's the twist. Riley was about searching a phone. It wasn't specifically about forcing you to hand over your password, and that distinction matters more than you'd think. So let's slow down and ask the real question. If police have your phone in their hands, can they legally force you to type in your passcode or say it out loud so they can get inside? To understand the answer, you need to understand two very different amendments that are both fighting for control of this situation. The Fourth Amendment protects you from unreasonable searches. The Fifth Amendment protects you from being forced to incriminate yourself. And when it comes to passwords, it's really the Fifth Amendment that becomes the main battlefield. Think about what a password actually is. It's not a physical object like a key that police can just take from you. It lives in your mind. And that's exactly why courts have wrestled with this for over a decade. When the government forces you to reveal a password, are they forcing you to perform a physical act, like handing over a key? Or are they forcing you to communicate something out of your own mind, which starts to look a lot like testimony? This is where a concept called the Foregone conclusion doctrine comes into play. And once you understand it, this entire topic starts to make a lot more sense. The doctrine comes from a Supreme Court case called Fisher versus United States, and it says that if the government already knows certain information exists and they already know you're the one who possesses it, then forcing you to produce it might not violate your Fifth Amendment rights, because you're not really revealing anything new. It's already a foregone conclusion. Now apply that to a phone password. If the police already know with reasonable certainty that incriminating files exist on your phone and that you and only you know the password, some courts have said compelling you to unlock it doesn't violate the Fifth Amendment. But if they're just fishing, hoping something incriminating might be inside without already knowing what's there, many courts have said forcing you to reveal your password would be unconstitutional because it would be compelling you to essentially testify against yourself. Here's where it gets even more interesting, and this is the part almost nobody talks about. Courts across the country have not agreed on how to apply this doctrine to phones. Some state Supreme Courts have ruled that revealing a memorized password is inherently testimonial, meaning it's protected speech from your mind, and therefore police cannot force you to disclose it. The Pennsylvania Supreme Court, in a case called Commonwealth versus Davis, ruled exactly that way, finding that compelling someone to reveal a password crossed the line into compelled self-incrimination. Meanwhile, other courts, including certain federal circuit courts, have been willing to compel password disclosure under narrower foregone conclusion arguments, especially when prosecutors can show with real specificity what evidence they expect to find. So what does this actually mean for you, sitting in that car on the side of the road, phone in hand? It means the honest answer is it depends on where you are, and it depends on what the government already knows. But here's what stays consistent almost everywhere in the country. You are never legally required to give police your password verbally on the spot during a routine encounter without a warrant or a court order. If an officer simply asks for your password during a traffic stop, that is a request, not a lawful command you must obey. You can decline, and in most circumstances, that refusal alone cannot be used as probable cause to arrest you. But now, here's a twist that trips a lot of people up, and it involves your fingerprint or your face. Some courts have drawn a fascinating line between a password, which lives in your mind, and a biometric identifier, like your fingerprint or your face, which exists on your body. Judges have reasoned that using your finger to unlock a phone is more like handing over a physical key than revealing a memorized secret. Because of that reasoning, some courts have allowed police to compel biometric unlocking even while refusing to compel password disclosure. In fact, a federal magistrate judge in California specifically wrestled with this question in a case involving a Google Pixel phone, ultimately finding that forcing someone to use their face or fingerprint to unlock a device could still raise serious constitutional concerns, especially when the unlocking essentially forces a person to authenticate incriminating content. This is exactly why some privacy experts and defense attorneys recommend using a numeric passcode instead of fingerprint or facial recognition if privacy is a major concern for you, because a passcode sits more solidly inside Fifth Amendment protection, while biometrics currently sit in murkier legal territory. Now, let's zoom out from phones for a second, because your question was really about social media. Does everything we just covered apply the same way to your Instagram, your Facebook, your Snapchat, or your email? Mostly yes, but there's an extra layer here that makes this even more important to understand. A lot of states have passed laws specifically protecting employees and job applicants from being forced to hand over social media passwords to employers or schools. States like California, Illinois, and Maryland have statutes preventing employers from demanding your social media login credentials as a condition of employment. But here's the catch that surprises people. Those laws are about employers, not police. They don't automatically extend the same protection to law enforcement, and that's a completely separate legal category.
For police specifically, the same Fourth and Fifth Amendment principles we already discussed still apply, but there's an added wrinkle. Because your social media data often lives on a company's servers, not just on your device, law enforcement sometimes doesn't even need your password at all. They can go directly to the platform with a subpoena, a court order, or a search warrant and request certain records under a federal law called the Stored Communications Act. This law regulates how and when platforms like Meta, Google, or Snapchat are allowed to hand over your data to the government. This is where the story gets even more layered, because there's a meaningful difference between basic subscriber information, like your name and email associated with an account, and the actual content of your messages and posts. Getting basic account information generally requires a much lower legal bar, sometimes just a subpoena, but getting the actual content of your private messages typically requires a search warrant based on probable cause, similar to what would be needed to search your home. So even if you refuse to give police your password, that doesn't necessarily stop them from accessing certain information about your accounts. It just means they usually have to go through the platform following a legal process, rather than forcing it directly out of you. Let's bring this back to a real-world scenario to make it click. Imagine police suspect someone posted threatening messages on social media. If they only want to know who owns the account, a subpoena to the platform might be enough. But if they want to read every private message inside that account, they generally need a search warrant showing probable cause, reviewed and signed by a judge. And in either case, they are going through the company, not necessarily forcing the suspect to type in a password on the spot. Now, here's the part where a lot of true crime and legal channels get this topic wrong, and I want to correct it clearly. Some content online claims that police can never force you to unlock anything, ever, under any circumstance. That's not accurate either. Courts have compelled password or biometric disclosure in certain cases, especially when backed by a proper warrant and strong foregone conclusion evidence. So this isn't a blanket shield that makes your phone or your accounts completely untouchable. It's a case-by-case legal battle, shaped by the specific facts, the specific state, and sometimes the specific judge. This is exactly why what you say and how you respond in the moment actually matters. If police ask you for your password during a stop or an arrest, you do not have to unlock anything for them voluntarily. The smartest response, according to most defense attorneys, is to calmly and respectfully say that you do not consent to a search of your phone or your accounts and that you would like to speak with an attorney before answering any further questions. You are not being rude by saying that. You are exercising a right that the Constitution specifically protects. At the same time, never physically resist an officer, never attempt to delete data in front of them, and never lie about what's on your device, because those actions can create entirely new criminal charges, completely separate from whatever they were originally investigating. There's one more twist that deserves your attention before we wrap this up, because it involves something called consent, and consent changes everything. If you voluntarily unlock your phone or voluntarily give someone your password because you feel pressured, confused, or intimidated, courts often treat that as valid consent, even if you regret it 5 minutes later. This is one of the most common mistakes people make during police encounters. They assume that because an officer asked nicely or acted friendly, that they have to comply. But politeness from an officer doesn't equal a legal obligation from you. You are allowed to be respectful and firm at the same time. You can say, "I don't consent to a search of my phone or my accounts," while still being completely calm and cooperative in every other way. So let's pull all of this together into one clear picture. Police generally cannot force you to reveal a memorized password during a routine stop without a warrant or a strong legal justification. Biometric unlocking sits in a legally grayer area, and courts are still working out exactly where that line falls. Social media content is often protected by a federal law requiring a warrant for private messages, though basic account information may be obtained with less. And nothing here means police have zero tools available. They can still pursue warrants, subpoenas, and forensic techniques through the proper legal channels. What this really comes down to is one core truth. Your silence and your refusal to hand over a password is not an admission of guilt, and it is not something police can weaponize against you as automatic proof of wrongdoing. The Constitution was built specifically to prevent the government from forcing people to become witnesses against themselves. And your digital life, as personal and revealing as it now is, falls directly under that same protective umbrella in most circumstances. If there's one thing I want you to remember after watching this, it's this. You always have the right to stay calm, stay respectful, and still say no. Knowing the law doesn't mean disrespecting the people enforcing it. It means understanding exactly where your rights begin and where they legally end, so no one can pressure you into giving up more than the law actually requires. If this video helped you understand your digital rights a little better, you're going to want to watch the video I made right after this one, where I break down exactly what happens when police ask to search your car during a traffic stop, and why the answer might surprise you just as much as this one did.